Hi, I'm Debra Effeney and I'm a Senior Associate at Michael Lynch Family Lawyers and also an accredited specialist.
Hi everyone, my name's Tiela Morrison and I'm a solicitor at Michael Lynch Family Lawyers.
Today, Tiela and I are going to talk to you about how to document an agreement. There's many types of issues that you can document in an agreement, but the most common agreement is a consent order. It's filed in the court by way of an application for consent orders and minutes of consent or terms of settlement. And the terms of settlement can contain a number of different issues that the court can make as orders. What are those issues, Tiela?
So we have property settlement matters, spouse maintenance and also parenting matters can be included in your consent orders. So for property settlement, it is basically the division of assets between the parties. In relation to spouse maintenance, the parties can agree that one party will pay an amount of money in terms of spouse maintenance, or the parties can agree that neither party will pay spouse maintenance. For parenting, it can include time arrangements during the school term, holidays, special occasions, and it can also state which school the children attend as well.
Yeah. So those application for consent orders are filed in the court, and if they're fair, just and equitable, and if the parenting matters are in the best interest of the children, the court can make those orders. Another way to document parenting matters is also by way of a parenting plan, which is not an enforceable agreement like a consent order, which is filed in the court, but still a very good way to document parenting matters. And again, Tiela, they can contain the same sorts of things that you talked about before, parenting arrangements, time for children. It actually has a little bit more scope where it probably can include some financial matters for children as well.
It can state the child support and school fee arrangements for the children, but again, it's not enforceable like a consent order. It's often a good way though for parties who have just separated and they'd like to trial an arrangement for the children that's not locked in.
Another thing that you touched on in the consent orders was spousal maintenance, so that can be formulated in a consent order, but it can also be put into a financial agreement, which is also an enforceable document, but it's not registered with the court. The difference between financial agreements, including spousal maintenance agreements, is parties do need to get independent legal advice, so it can be more costly and it can be a more complicated document. So generally consent orders are the best way to go. Financial agreements can also, as Tiela has talked about for consent orders, document property settlement matters, the division of the property pool, who's going to retain what. But again, financial agreements, parties do need to get independent legal advice.
The main difference between the consent orders and the financial agreement is that for the financial agreement, the parties are opting out of the court's jurisdiction. So the agreement may not necessarily have to be just and equitable, which the court considers. But if the parties wish to divide their assets in that way, they can do it in the form of a financial agreement.
And child support is something we talked about as well. There are child support agreements as well. There's binding and limited child support agreements. Again, with binding child support agreements, you need to get independent legal advice. Limited child support agreements, you don't, and they're only valid for 3 years.
Yeah, so the most common and what we prepare is the binding child support agreement, since it is in force until the most common terminating event being the child turning 18.
The most important thing to take away from today is if you have an agreement, be it for property settlement, parenting matters, child support, you can document it in an enforceable way. And it's best that you do so, particularly for property settlement matters, because if you don't, you may find that years down the track, your former partner comes back wanting to do a property settlement. There are time limits though that apply. What are those, Tiela?
If you are married and you've received a divorce order, you have 1 year from the date the divorce order takes effect. For de facto partners, the time limit's different, and that is it's 2 years from the date of separation.
So it's best to get an agreement done before the time limits expire, and there's no guarantee even when the time limits expire that your partner couldn't bring an application out of time. So it really is best to formulate an agreement and put it in place prior to those time limits expiring. But we can see you at any time if you did want to make a consultation with us. We're available in person, by Zoom, Skype, telephone. So don't hesitate to give us a call. Either Tiela or myself or any other member of our firm would be happy to see you.
Thank you for listening.